Thank you, Mr. Chairman. I'd like you all to look at the seal behind the chairman, because it has what the people of the county of Charleston felt were important principles to promote when they formed this government. And you'll see up there, pro bono public, for the public good. And unfortunately, this hearing misses the point that the purpose of a National Labor Relations Board investigation is to determine what's in the public good when the NLRB exercises its constitutional responsibility to investigate whether labor laws have been violated, in this case by Boeing, and if so, what a proper remedy for those violations should be. And if you remember only one thing, you need to think about not just what due process means to the parties to this complaint, but what it means to you and your families and your friends and your neighbors. Because this goes much deeper than an NLRB hearing. And the problem with this hearing is it involves an unprecedented improper interference by Congress with a pending adjudicative proceeding as defined by the federal statute and based on years of precedent. So what we should be talking about is not what the person who is in charge of prosecuting that case is doing, but whether in fact Boeing broke the law and what should be an appropriate remedy. One of the things that you learn in your first days of class in administrative laws is that administrative agencies act in one of two ways. One is by rulemaking, where there's an opportunity for expansive public input and congressional input, and all of us engage in that on a constant basis. But the other type of action by agencies is called adjudication, and it's just like a judicial proceeding. And just as you aren't supposed to tamper with juries who are deciding the facts in a case in a court, you aren't supposed to tamper with witnesses who appear in front of that court, even though they aren't involved in the process of deciding the outcome of that case. So what we should be talking about is things that are the basis of our Constitution and how this country is founded. Let me read this to you. He has obstructed the administration of justice by refusing his assent to laws for establishing judicial powers. He has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. That's in our Declaration of Independence, because our founding fathers didn't want people interfering with judicial processes, which is what was happening in England. And that's why when we're talking, and the chairman mentions the threat to the reindustrialization of the American workforce, folks, we're involved in a race to the bottom right now. We had 397,000 factories in this country at the beginning of the last decade. We only have 343,000 now. That's a closure of 54,000 factories, a loss of 5 million jobs. That means every day 15 factories are shutting down. That's what we should be talking about today.
I thank the gentleman. We now go.
Well, what Mr. Ross said, and it's in the record, is the NLRB is an arm of the United States Congress, which is blatantly false. It's part of the executive branch. And when they're performing an adjudicative function, it's a quasi-judicial proceeding. And that's why we've been talking about due process throughout this hearing. Thank you, Professor Getman, for not convicting Boeing on the basis of the very tiny record we've been talking about here today. And I said at the beginning of this hearing that if you remember one thing about what's going on here today, remember due process. Because there's been many people talking about this as being a baseless complaint. Well, folks, if you remember anything about due process, think of all those Western movies you've seen where a posse has cornered a horse thief, and somebody in the posse says, "Let's hang him." And the sheriff says, "No, let's give him a fair trial, and then we'll hang him." That is not due process. And we are not here today to substitute our judgment for the NLRB, and that's what's wrong with this proceeding. Now, since Mr. Kucinich brought this up, let's take a look at the statement by Mr. Jim Albaugh that was made on March of 2010 to the Seattle Times. Can we play that now?
But again, the overriding factor was not the business climate, and it was not the wages we're paying people today. It was that we can't afford to have a work stoppage, every 3 years. we can't afford to continue the rate of escalation of wages as we have in the past. You know, those are the overriding factors.
Would the gentleman yield?
Now, Mr. Solomon,
Would the
I only
gentleman
have
yield?
5 minutes, Mr. Gowdy, and
I'm
I
happy-
want to complete
I'm happy
this.
to
I
stop
will
the
not
clock.
yield. I will not yield.
Will you put
I
the
will not
remainder of the
yield.
document in evidence under the rule of completeness?
You have an opportunity, Mr. Chairman. I would ask for order.
I would advise the gentleman that by unanimous consent, the entire document is in the record. We will also post the entire video on the website. The gentleman may continue.
And can I have all of my time
You have all your
reinstated,
time.
Mr. Chairman?
One of the things that we do back here real well is they actually stop when that kind of stuff starts. So they'll continue as you now continue.
Great. Now, one of the things that we know, Mr. Solomon, is that there is a huge difference in the law between discrimination and retaliation, and I want to make that clear as well. Because if you are discriminating against an employee on the basis of race, religion, sex, gender, some other protected classification, that's a violation of the law. And yet, if you retaliate against that employee because they engage in the process of protecting their rights by filing a complaint, that is a separate and distinct violation, is it not?
Correct.
And so when you are bringing a charge against Boeing for retaliation, that has nothing to do with the underlying action, but whether in fact this video and other evidence you plan to present at that hearing will provide a legitimate basis to prove that Boeing took the action it did because of a desire to retaliate against protected employees. Isn't that correct?
That is correct.
Now, Ms. Gamara, you had a great comment in your statement, and you said there is not yet an evidentiary record in the Boeing case. And that's really what part of the problem is here today, is it not?
The process certainly contributes to the problems that everyone's talking about.
Right. And you, in fact, made the comment that you greatly respect the members of the board, the acting general counsel, and others employed at the agency, a fact that is a feeling that is apparently not shared by some of my colleagues. But one of the things you mentioned at the conclusion of your wonderful appellate brief, which has 79 footnotes, I believe that's a new record for an opening statement, Mr. Chairman. It was eloquent and well argued. You happened to mention the Dubuque Packing Company case. And my wife grew up in Dubuque, Iowa, in a working class home built by her father just down the street from the Wallert family mansion that owned the Dubuque Packing Company. Now, is the Dubuque Packing Company in existence today?
I don't know the answer to that question.
It is not, sir. It is gone with the wind. A company that used to employ 3,500 employees, pay a payroll of $20 million in the 1960s, and Mr. Chairman won the gold medal for the best canned ham at the California State Fair in 1960 and 61, a fact I knew you would appreciate, is gone. And that's what the National Labor Relations Board is all about, is protecting the rights of workers and employers and providing a fair process. Now, that process may take too long, and I wouldn't disagree with you on that, but we know that people like Judge Marriage in the Northern District of Virginia were successful in significantly decreasing the amount of time it takes to process contested cases if they really put their mind to it. So rather than complain about the length of time and the burden on the employer, why not just improve the process so that it's fair and more responsive to the needs of everyone?
The gentleman can answer briefly, but his time has expired.
Yeah, the only thing that I would say is there are also issues that I and others think are significant in relation to the interpretation of law and the remedy being sought in the case.
Right.
With that, we go to the judge.